you know, I'll leave it to you to decide when you're going to kick it off. But
Okay.
Thank you.
Well, good afternoon, everyone. My name is Tim Scott Young, and I'm the National Claims Manager at Marsh. And I'm very fortunate today to be joined by Luke Stratford, who heads up our Claims Solutions area for the Pacific region, as well as by also with Mark Darwin. And Mark is a partner at Herbert Smith Freehills. And the three of us today are going to take you through some exciting developments following the verdict which was handed down in the COVID Australian test case in the middle of last week. So we will canvass a number of important issues through the claims webinar this afternoon. We thought it would be a very timely fashion. It's obviously very topical. At this point in time, there's been some media coverage of it at the end of last week. And I think it's really time to connect with as many clients as we can and give them some insight to what we see coming out of the test case. And obviously also, next steps and how we proceed from here. So we'll touch upon the Australian position with Mark. And he'll provide us with a summary of the judgment, both in Australia and the UK test cases, and also some anticipated next steps and what we can expect. And then I'll have Luke follow that up with really the claim solutions piece, so how we can help you as our clients in preparing our claim and how our forensic accountants work after coverage is confirmed. And obviously help define what is a financial loss under the policy. So we'll then conclude. We'll have some questions and answers. We have a lot of you on the call today, so I think it's doubtful that we'll get through all those questions that have been posed. There have been some submitted prior to the webinar this afternoon, but certainly, as you know, this webinar will be recorded. And the contents will be sent around to everyone who registered, and we'll also include the questions and we'll submit some answers with that as well. So you'll get some response to the questions that are submitted in the follow-up if we don't get to them this afternoon. Okay, so just a little bit about Marsh and what sort of numbers of claims that we've received today. So just under 700, and that's from March this year. Obviously, most of them in the travel arena. So, and with about 120 or so property BI ISR claims. And of those 120 claims, so far we've received about 40 denials coming from the carriers. Now, interestingly enough, only about a handful of those denials relate to the specific exclusion under the Quarantine Act that's the subject of the Australian test case. The other 35 odd denials also relate to other grounds, and this is an area of consideration that we'll look into today and have some further discussions. Notwithstanding that, our claims are being submitted to carriers within our 3 days, 100% in accordance with our service metrics to all our clients. So that remains unchanged. There's no backlog within the claim organisation. And in fact, in preparation of the test case judgment being released, we have strengthened our claim resources within Marsh. We have put into place a number of fast-track processes with designated large carriers for a fast-track claim process. So we do the claims department stands ready and able to assist you with your inquiries and claim submissions as we move forward. So what I'll do in the next 2 slides is just give you the latest updates in a snapshot of what we're looking at. So as probably all of you are aware now, the ICA supported the commencement of a test case back in August 2020. So that was to the New South Wales Supreme Court, and it considered one specific issue, and that issue was the application of an exclusion of diseases notified under the Quarantine Act of 1908, which has obviously now been repealed with the Biosecurity Act that was enacted in 2015. And the test case related to two business interruption policies of HDI and Hollard, which was seen by the ICA and AFCA as being reasonable representation of BI exclusions that we're seeing in the Australian market. Now, as you all know by now, the New South Wales Court of Appeal unanimously decided against the insurers, finding that the exclusion did not apply to COVID-19, which was great news. Now, it was a unanimous verdict. It was 5-0. It included the president of the Court of Appeal and also some very senior insurance litigation judges that made up that appeal panel. And that's an important consideration when we sort of look at the issues of, what avenues do insurers have in terms of appeal. And there is a seek special leave to appeal to the High Court of Australia. So in this case, there's no right of appeal. The insurers have to seek leave to appeal, and that has to be filed by the 16th of December, so next month. Important to note that insurers have only denied a claim on the basis of such an exclusion will now have to reconsider their prior position. So getting back to sort of the numbers that we've been seeing, that only related to a handful of claims. The majority of claims included a number of conditions which the insurers say were not met. So it's important to note that insurers may still be able to rely on other provisions to deny a claim. And this test case did not decide all the issues, unfortunately. And there are a number of other issues which the ICA is currently talking with insurers, the Australian Financial Complaints Authority, AFCA, about a further test case, which might explore other grounds on which insurers might deny claims. And that could include obviously things like proximity, prevention of access, and other matters relating to COVID-19. And these sort of issues also arose in the UK test case, which was decided in favour of policyholders, which is a really positive development, late last month. And Mark will also sort of talk about the implications of the UK test cases and how that might apply to how we consider claims in Australia. And finally, ASIC has put insurers on notice regarding expectations about their response to the pandemic. It's asked them to consider their conduct in the light of the current circumstances, obviously surrounding sort of small business, and obviously the state that they currently find themselves in, and obviously to act in a fair and professional manner that is in line with their duty of utmost good faith. So insurers have been clearly put on notice that they have to respond to claims from policyholders in a timely and speedy fashion, taking into account obviously the appeal process. Okay, well look, I will now like to obviously introduce you to Mark Darwin. So Mark, as I mentioned before, is a partner with Herbert Smith Freehills. He heads up the insurance practice there for Australia, and is focused entirely upon assisting policyholders with major claims. He's handled many complex business interruption claims in his career, ranging from salmonella in peanuts, you might remember those claims, to floods in open cut coal mines. Most recently, he's been assisting his London partners and representing the FCA in arguing for the policyholders' positions in the UK FCA test case. And he's got some terrific insight, I think, that he can offer us this afternoon. So, Mark, thank you and look forward to your comments.
Thank you for that, Tim, and thanks to Marsh for inviting me along to talk today. It's been exercising a lot of people's minds and getting a lot of publicity in the industry and in the mainstream media. But there are three problems or three reasons why there's no simple answer to is BI cover from COVID covered. Firstly, there's just a range of different policy wordings. There's not one industry standard wording. There are some typical wordings, but because policies are different, there's no one answer to all coverage questions. Secondly, each claim is going to depend upon its facts, what type of business they were, how they were impacted, how the government orders affected those businesses. And thirdly, there's no universal world court or world authority that dictates how these claims are going to be handled throughout the world. Each jurisdiction has its own systems and ways of doing things. And so while they might be influential, there's a potential for different approaches to be taken in different jurisdictions. So what we did in the London case was we picked 21 fairly typical wordings and we categorised the types of businesses that have been affected into 6 or 8 categories. And we got some representative guidance as to what the court found in relation to some of the key issues. And what I'm proposing to do today is take you through at a high level the guidance that we can take from that so that people are aware of what the issues are and can have some understanding of what to look for in looking whether you might have coverage for your business interruption losses or your client might have coverage for their business interruption losses. And so the starting point is just to think about the 3 elements to a successful BI claim, which I've got there. The first of it is that there's an insured trigger, so that the circumstances that have happened have triggered the cover in accordance with the different options that are in the wordings. Secondly, it's got to be a not excluded trigger, so is there a relevant exclusion which applies? And largely the Australian test case was around one of those exclusions, and I'll go on to talk about that. And the third issue is, did the insured trigger cause the loss that you're claiming? And in particular, this brings into play what other circumstances may be taken into account in assessing what results the business would have obtained if the insured trigger hadn't happened. So were there trends or other circumstances that would have meant that the business wouldn't have done very well in 2020 anyway? If we can go to the next slide. The first element then is the insured trigger. And typically, the trigger for business interruption cover is physical loss or damage to insured property. Now, I say typically because, as I say, there's not all policies are the same, but it's generally the case that business interruption policies start from the premise that one part of it, Section 1, typically will cover physical damage to the premises. And if that happens, while that damage is being repaired, the Section 2 coverage for business interruption will cover the consequential losses that are to the business operations while the damage is being repaired. So what I've extracted there is really an extract of the typical wording under the ISR Mark 4 wording that says in the event of damage happening and the business being interrupted, insurers will pay. Now, the first problem is, and the reason this has become controversial and people are looking for other reasons, is that COVID-19 is not physical damage. It's even if you could argue that it was, and there are some cases in the US that are trying to argue that it's a contamination on the premises and therefore it's physically damaging the premises. You wouldn't get very far with that argument anyway, because the first problem you'd have, at least in Australia, is that not many premises have a case of COVID on them. So they didn't damage the insured property. It was just sort of in the community and around. Secondly, even if you did have COVID on your property, it wouldn't cause any loss because it could be cleaned within a very short space of time. So the ongoing losses wouldn't be in consequence of the damage. They would be due to the other circumstances and the wider outbreak. And thirdly, any claim that's based upon damage would immediately be met with the general exclusion 4A in the ISR policy, which excludes damage occasioned by disease. So we need to look elsewhere if we're going to try to find BI coverage for COVID-related losses. We just go to the next slide, please. These are some of, but not all of, what we call the non-damage extensions, which have the potential to assist people in getting coverage for BI losses. The top left is the disease extension, and this is the one that gets most airplay. It says that we'll cover you for interruption or interference with your business due to an outbreak of an infectious or contagious human disease occurring within a 20-kilometre radius of the premises. Sometimes it says within the vicinity of the premises, sometimes it has a different radius, but that's broadly what the extension is. There are then exclusions to that I'm going to come to, but that's the main one that people have been starting to look at. The other one to the top right is the civil authorities extension. What that does is it deems the actions by authorities to be damage that's recoverable under section, the consequences of which are recoverable under section 2. So it says that the policy is extended to include loss resulting from or caused by any lawfully constituted authority in connection with or for the purpose of retarding any conflagration or other catastrophe. A couple of other examples there. There's below that, there's the loss of attraction extension, which is similar, where the action of authorities prevents or hinders access or affects the attraction of people to the vicinity of the premises. And on the left, there's a prevention of access clause, where the government action prevents or hinders access to the premises. There's a hybrid clause in the bottom left, which talks about the closure by the government because of an outbreak, and it's probably one of the better, wider extensions. Although, again, when you come to exclusions, that's where that one starts to hit some problems as well. So if you've got something like one of these, then you should be looking pretty closely at your coverage because you might have got to first base. Let's go to the next slide. The second issue then is, well, is the coverage that you thought you had triggered excluded by some other provision of the policy? And relevantly, there are two key exclusions that have the potential to apply. At the top half of the page, the exclusions you see to the disease extension that I outlined about the outbreak within 20 kilometres of the premises is the one that's been the subject of the ICA test case. If at the top is the wording that existed up until 2015, and it said, however, there's no cover for diseases to be declared as quarantinable under the Quarantine Act and subsequent amendments irrespective. Now, of course, that legislation, as we now know, was replaced in 2016 by the Biosecurity Act, and policies that were updated were changed to make that exclusion say, however, human-listed diseases or other infectious human diseases under the Biosecurity Act and its subsequent amendments are specifically excluded. So, depending upon whether you've got the top exclusion or the bottom exclusion, you might have a problem. You've definitely got a problem with the one that refers to the Biosecurity Act because COVID was notified under the Biosecurity Act. And what the test case dealt with was the insurers said, well, when we said Quarantine Act and subsequent amendments, we really meant by subsequent amendments the Biosecurity or any legislation which replaced the Quarantine Act. So you effectively read those two exclusions as the same thing, and COVID is excluded because it was nominated under an amendment to the Quarantine Act, namely the Biosecurity Act. That was the argument, and I'll come to how that was decided in a moment. The other exclusion that we're seeing getting thrown up by insurers is that general exclusion, perils 4A, that I referred to earlier, which excludes disease in the context of a physical damage claim. So this is a general exclusion which applies to physical loss, damage occasioned by happening through a whole bunch of things you can see there, and disease is amongst them. Now, bear in mind, it's important that this is a general exclusion. the two exclusions that refer to the Quarantine Act and the Biosecurity Act are not general exclusions. They are only exclusions to the disease extension. So, you didn't have a claim, then you do have a claim potentially because of the insured trigger for the disease, but then you might lose that claim again if an exclusion applies. And there's an issue as to whether in the general perils exclusion, a general exclusion for physical damage occasioned by disease can knock out the coverage that's offered under an extension for non-damage type coverage. I'll come to that in a moment. Next slide, please. So what the ICA test case did, and just some context on this, AFCA the Australian Financial Complaints Authority, unlike the UK authority, is not the regulator of insurances Australia. It is merely an adjudicator of disputes between policyholders and insurers. And so it didn't have the power itself to bring a test case. So it worked with the ICA, who was pretty keen, we understand, to not have AFCA decide these things because insurers can't appeal from decisions made by AFCA. So the ICA funded a test case of some clients that had lodged, so some policyholders that had lodged claims with AFCA, and they thought that these would be appropriate to have it resolved. And the two cases both had the Quarantine Act exclusion that was in the top of the previous slide. And as is probably notorious about this claim now, when the Quarantine Act was in existence, a number of diseases had been notified under that, most famously ones you've heard of like the avian flu, bird flu, swine flu, SARS, and MARS, the Middle East Respiratory Syndrome. That legislation was repealed in 2016. The Biosecurity Act came in, and there was no dispute that at the policy inception, COVID-19 was not listed under either act, but on the 21st of January, it was listed as a human disease under the Biosecurity Act. Now, obviously some policies were not updated, some of them are, but the question was whether an exclusion in a policy that hadn't been updated that refers to quarantinable diseases notified under the Quarantine Act and subsequent amendments excludes COVID-19. This was given special leave to go, not as it normally would, to a single judge and then on appeal to a three-judge bench of the Court of Appeal. This one went straight to a 5-judge court of the New South Wales Court of Appeal, including the President of the Court of Appeal and the Chief Justice of the New South Wales Supreme Court. And they held 5-0 that the exclusion did not apply. There were two arguments run by the insurers. First of all, they said, well, you should read the words and subsequent amendments as being and subsequent legislation that replaced the Quarantine Act. But the court held that those words and subsequent amendments are not ambiguous, they're completely unambiguous, and they're not broad enough to include the reference to an act which was replaced by another act. So legislation can be amended from time to time, and that would have been good enough. But when legislation gets repealed and completely replaced, they said that does not apply. And they really recognise that, well, that might have been what they wanted, but the quote on the right said, the judges said, look, there comes a point where the court has to remind itself its task is to discover what the parties meant from what they've said, and to force upon the words a meaning which they cannot fairly bear is to substitute the bargain actually made for one which the court believes could better have been made, which is an illegitimate role for the court. The second argument was that, well, we've made a mistake and you should correct the mistake because it's absurd to be referring to an outdated act. And the court said, well, it's not so absurd. There's a completely different regime under which diseases become quarantinable because of a notification by the Governor-General under the Quarantine Act and the Chief Health Officer nominating diseases under the Biosecurity Act. It's a different regime. It's possible that a different way of noting what diseases were excluded was intended. You might have intended it, but it's not so absurd. And importantly, the insurer's legal counsel, who was Brett Walker QC, conceded as part of his submissions that the insurers were not aware that the legislation had changed. And so one of the judges says, well, you can't come along and say that you intended to refer to the Biosecurity Act, but you accidentally, in putting this in writing, referred to the Quarantine Act, because you didn't have the intention to refer to the Biosecurity Act in the first place on your own argument. It was just something that you never turned your mind to. And so effectively it was decided on the basis of pretty orthodox construction of contract principles that we've got to give some effect to the words used, and they've got an ordinary grammatical meaning, and it's not the court's role to start substituting the deal that was done for the deal that you wish you'd done. So what does that mean? If we go to the next slide, everyone's getting very excited about this case as to meaning that everyone's now got a BI claim. That's not necessarily the case, because one would think that most policies have still have been updated and refer to the Biosecurity Act exclusion. So if you've got a disease exclusion and a reference in the exclusions or the proviso that says, however, listed human disease under the Biosecurity Act is excluded, then you've still got a problem, and you have to find another way to make a claim because you have not got a claim under the disease exclusion. If you are lucky enough not to have had your policy updated, then you've got a claim under the disease exclusion, and subject to satisfying the other elements, then you're looking pretty good at the moment. And that's obviously the reason for the nervousness. I don't have the data on how many policies are out there that weren't updated, but from from some of the media reports of what some of the insurers are doing, there must be a large number of policies that haven't been updated and that still refer to the Quarantine Act, because they're the only claimants that benefit from this test case decision. Even those claimants still have to overcome the argument around the general exclusion for disease, and they also have to prove that their loss was caused by the insured trigger and that the adjustments clause doesn't take away from the coverage they think that they've got. Just go to the next slide, please. So let's just deal with what the calculation of the loss has been. Once the loss has been triggered and it's not excluded, we then say, well, how much money do you get under the policy? So the broad formula is your loss equals your rate of profit multiplied times your standard turnover, what you would have done minus what your actual turnover is, what you did do, and you get your profit margin on that. And the standard turnover is defined as the turnover you did in the same period in the previous year, but then that's then adjusted for trends and other circumstances that would have affected your results this year anyway. So if there'd been a price hike or a commodity crash or a major customer that had gone bankrupt, that would have affected your results anyway. All those sort of things affect why last year's turnover isn't necessarily the basis of what you would have earned this year. And they call it the trends clause or the adjustments clause or the other circumstances clause. And broadly, you'll see in the middle there, it looks to adjust for trends or variations or other circumstances affecting the business, so that the adjusted figures represent as nearly as reasonably practical the results which, but for the damage, would have been obtained in the relevant period after the damage. Now, that's a pretty straightforward concept when you're dealing with physical damage. So if you had a fire in your factory, but for the fire in the factory, what was the business on trend to do? Same as last year, or were they looking, because of a commodities boom, that there was going to be a 10% increase this year? That's what it's designed to do, or indeed if it was going down, the figures might be adjusted downwards. But it's more controversial when you're dealing with COVID-related claims, because at first read of it, you would say, let's take the disease clause. Well, but for the outbreak within 20 kilometres of the business, what would the results have been during 2020? Having regard to all the other circumstances that are happening around the world, the government action, the downturn in the economy, etc. And the insurers argued when claims first started getting lodged here that, well, what you've got to look at is the outbreak within 20 kilometres of the premises. Let's assume that you can satisfy that you have an outbreak that's inside the 20 kilometre zone around your premises. The insurers said, well, what we do is we assume that there was no outbreak within that 20 kilometre radius, but that all other circumstances are the same. So the COVID was running wherever it was in the community, the government was shutting things down, the stock market was crashing, confidence was going, people were losing their jobs, etc. You know, what would your results have been anyway? You know, not very much. If we go to the next slide. That type of attitude was based upon a long-held industry meaning of but for the damage, based upon a case called the OEH case. Now, people might have heard this being mentioned. It stands for the Orient Express Hotels case. And that was a good example of the unfairness that can come about this type of approach. What happened there was a hotel operating in New Orleans was damaged during Hurricane Katrina. People might remember that that was a situation where the levee bank around New Orleans collapsed because of the hurricane and flooded the entirety of the city. There was an exclusion zone around it. No one was allowed to go in. It was very dangerous. The hotel, you know, lost all its bookings and it lodged its claim based upon its normal occupancy, which was about 90%. And the insurer said, well, we don't have to pay this because your occupancy would have been nil anyway, because no one was visiting New Orleans in the aftermath of the hurricane. It was flooded, there was an exclusion zone. Your standard results would have, you know, tanked down to nil. So we can't look at last year's results. The trend circumstances clause entitles us to treat your results as if you were an undamaged hotel in a damaged city. And that was it was in New Orleans, but it was an English law arbitration clause in the policy. So it went to 3 arbitrators in England, one of them called George Leggett QC at the time. I'll come to the relevance of him in a moment. He decided that the standard occupancy was as the insurers submitted it should be, and that is that it would be, what would the results would an undamaged hotel sitting in New Orleans would have done during that period, which was not much, so the claim failed. That was then appealed to Justice Hamblin of the High Court at the time, which is, in England, the High Court is like our Supreme Court and their highest court is the Supreme Court. It's the other way around in Australia. We go from the Supreme Court up to the High Court. So the High Court there held that the arbitration decision was correct. Apparently it was appealed, but it was settled before the appeal judgment came down. So you can speculate as to why that might have been the case. So this was a key issue in the London UK FCA case that we ran over there, where they appointed 2 High Court judges to hear it, and they overruled the OEH case. There was arguments about whether the OEH principle applied to non-damage extensions, and they said that there was no reason why it shouldn't. But what they importantly held with it is that all elements of the insured trigger should be excluded from the counterfactual. And I've quoted there, and I'm going to read it out. This is probably the most important passage in the judgment, because the insurers had argued, as I said before, well, you should just forget about the 25 kilometre radius and assume you take that out of the equation, but everything else was happening. Before I go to the quote, what the insurers accepted was what we argued, which is the purpose of a clause that says that you're covered for outbreaks within 25 miles of your premises is not to just look at the outbreak within the 25 miles. The argument we ran was that, no, you're covered for an outbreak which comes near enough to your premises to affect you. And so if it comes within 25 kilometres of your premises, then the coverage triggered. And the court accepted that argument. And that's really important because that enables the policyholders to rely upon the wider impact of the outbreak beyond the 25 kilometres. And what the court held there was the fact that it was envisaged that a disease up to 25 miles away might be followed by interruption to the business demonstrates that the parties must have contemplated that the actions by authorities might affect a wide area, and that they must have also contemplated that the authorities might take action in relation to the outbreak as a whole and not just to particular parts within the 25 kilometres. And importantly, apropos the OEH test, This means that one takes out of the counterfactual, that is the assumption as to what basis do we assess the business, the interruption referable to COVID-19, including via the authorities or the public response to COVID-19. So that's the big thing that comes out of the OEH case. That principle can be applied widely across all of the coverage extensions if the same approach is taken in Australia. Now, if that decision, you may have heard, is under appeal to the UK Supreme Court, it's been leapfrogged straight past the Court of Appeal in London and to their highest court, which is the UK Supreme Court. And they've got 5 justices sitting to hear that. And the little tidbit of curious and problematic potentially challenge that we've got here is that Justice Hamblin, who used to be on the High Court, is now a Supreme Court Justice. And George Leggett QC is also a Supreme Court Justice. So the 2 judges that were in OEH are part of the bench that are deciding this issue. So you might wonder whether they've had cause to consider in the last 10 years whether their decision was a good one or not. Can we just go to the next slide? So effectively, what the UK FCA test case judgment says, by way of examples, is that you replace the words "but for the damage" with the words of what the insured trigger is. So on the left, for the disease extension, you replace it for "but for the interruption to the business due to the outbreak within a 20-kilometre radius, including the authorities and public response thereto." So that's a pretty wide level of coverage. Of course, you have to have COVID within the 25-kilometre zone. So factual differences in Australia might be, in the UK, the disease was everywhere because the government didn't act as quickly as we were able to see it coming here. So there might be different factual situations in Australia, but that's why there's room for optimism if you don't have the biosecurity extension. In the prevention of access clause also, what the court held there on this particular prevention of access clause is that you don't just assume the lack of access, but you assume the reasons for the lack of access or the reasons for the action by the government. So again, here, the insurers had argued, well, if you were closed by the authorities or the authorities took some action, what you do is you assume the authorities didn't take that action, but you assume everything else is the same. So you assume that there was still a pandemic going throughout the community, but that the government wasn't doing anything about it. And you look at what the businesses would have been. But the High Court said, no, that's not right. One of the analogies they looked at was if you got a truck that's carrying some sort of acid that would be harmful if breathed, if it rolled over in the CBD and the government cordoned off the CBD for a period of time to save the public health incident from that, and you had coverage for actions by authorities and prevention of access, it would be ridiculous to assume that you assumed that the truck rolled over and that the gas was poisoning everyone in the CBD, but you assume the government didn't take any action as part of your insurance coverage. Of course, you would assume that the government didn't take action and the thing that made the government take action had not happened either. Next slide, thanks. So there's a bunch of other issues that were decided and in the UK case that are the sort of things that people will come up against in other claims. Firstly, there was a debate about what does action by authorities mean. The insurers had a bit of a win here. Only legislated enforceable actions are actions by authorities. Recommendations and exhortations to stay at home, etc., by Boris Johnson were not held to be actions by authorities. It was a great passage. They had an argument about whether the recommendation of health authorities to eat 2 veg and 5 fruits a day was a recommendation, and that wouldn't be an action by authorities, and so that held some sway with the judges. The meaning of what prevents means. Some policies only referred to prevention of access. Some of them, of course, refer to prevents or hinders access. But if you've got a policy that only talks about prevention of access, then the High Court held that only complete closure of the premises was a prevention of access. One of the examples they gave was of a pub that didn't sell, didn't have takeaway. If they were closed and then they opened up a takeaway business, and that was good enough. But if they had a takeaway business anyway and they just couldn't serve on premises, but their takeaway business continued, then they weren't prevented from, or they weren't closed by the authorities. Vicinity was another clause that the court looked at, and they said, well, it really depends upon the context. If there's no mileage in the vicinity and you're talking about an outbreak in the vicinity, well, it might be the whole of the country, probably. But if you're talking about government response to an emergency in the vicinity of the premises, that indicates some sort of local or neighbourhood type connection to your premises. And so maybe if you've only got that sort of coverage, you're not going to have much luck on your trigger, or at least under your trends clause, if you're taking that out of the equation. Interestingly, the insurers ran in the English case the general exclusion point and said all of this doesn't matter anyway because we've got this general exclusion for a disease. The court said it's hardly going to be likely that the parties would intend to take with one hand what they gave you with the other. So if they've given you a specific extension of coverage, then that would not be excluded by a general exclusion. Essentially, that the specific extension overrules the general exclusion. The other issue that I expect to be the subject of some debate in Australia will be the factual differences between the UK and Australia. They might not be huge, but there's certainly the potential there. The UK really had the reverse to here. They had a widespread pandemic and the authorities were very slow to act. And when they did originally act, they were recommendations, and then they only brought down legislative rules later in the play. Whereas here, our government got ahead of the game, and most of the loss here was really because of the government shutdown rather than because of the actual pandemic in the community. So there might be different arguments in Australia. I've got two more slides left. So just quickly, the next slide. These are the things that are being appealed. You know, whether the COVID and the actions of the public and the authorities is all one indivisible loss, or whether you can split them up between the different things that happened, and whether it was correct to overrule OEH. FCA is appealing whether only legislative actions amount to actions by authorities, and whether only complete closure amounts to closure or prevention. They're also taking on whether if the trend of the business was downwards because of COVID before the actual government ordered the businesses to be shut down, whether that was a trend that can be taken into account in adjusting the claim or not. I just got one more slide. I'll just talk about a case which we're watching with great interest, which is the Star City case. This is all public information. We're not involved in it. It involves the Star City Casino, which was in a category of businesses that was ordered to be closed by the orders of the authorities to prevent the spread of COVID. It has got the civil authority extension, which is in the middle there. That's the basis of its claim, that it includes loss resulting from or caused by any lawfully constituted authority in connection with or for the purpose of retarding a conflagration or other catastrophe. So they say that's been triggered and they've suffered loss. They've got the perils exclusion, the disease perils exclusion on the left-hand side, which is the general exclusion. And they've got a disease extension as well, which refers to the Biosecurity Act, you see on the right there, although erroneously refers to quarantinable disease. Now, one would have thought the insurers will get up that a quarantinable disease listed under the Biosecurity Act is as good as saying a human listed disease under the Biosecurity Act, but that argument doesn't seem to be taken by the Star, because the Star says, well, we're not lodging a claim under the disease extension, so that exclusion's irrelevant to our claim. We're only claiming under the civil authority extension. So what the insurers are arguing there is that the reference to loss in the extension in the context of the rest of the policy must be a physical loss. The second argument they've got is whether the expression conflagration or other catastrophe extends to COVID-19. Conflagration means a large fire that's burning out of control, and they say, oh, you really got to look at natural catastrophes. Now, I would have thought there'd be a reasonable argument that COVID was a natural catastrophe, and I wouldn't want to be the barrister trying to tell a judge that COVID-19 was not a catastrophe, but that's one of the arguments they're running. And they're also arguing that the general exclusion for disease and the reference to the Biosecurity Act in the disease exclusion extension is sort of general evidence of the intention of the insurers not to cover these type of diseases or diseases at all. So it's a bit of a vibe argument, really. That was also run and lost in the UK case. So they're going to rerun that argument in the Australian case, and they're obviously entitled to do that. Interestingly, this has been grabbed by Justice Alsop, who's got an insurance list in the federal court. It's listed for hearing on the 29th and 30th of April next year. Inevitably, it'll be appealed to the full court. Whether they leapfrog that one straight to the High Court, we'll get some guidance on that, presumably by what happens with the ICA test case. But that one is we're really waiting for the outcome of that one with interest. So that's all I've got for the moment. So I'll hand over now to Luke to talk about some of the practical issues of claims.
Thanks, Mark. Appreciate all that. A lot of information to digest. Just by way of background, the Marsh Claims Solutions team is an industry-leading group of claims professionals who deal with some of the largest and most complex of losses. Our vision is to create the definitive claims experience for clients through our expertise and our innovation. We support you, our clients, through this complex claim life cycle and assist from notification to the management of insurers, experts, while representing your best interests. We are a combined advocacy and forensic accounting team, and we offer the following: a single point of contact, real bench strength based on experience and expertise, and a multidisciplinary team, including lawyers, forensic accountants, and loss adjusters. Thanks, Tim. So how can we assist you with your COVID-19 claim? Our claims advocacy team is here to help you interpret your policy coverage and assist you to notify your claim appropriately. We can help you notify insurers of a potential claim whilst the legal framework is being resolved. We analyse the facts and the policy as the claim evolves and advise on maximising coverage opportunities. Navigating the frameworks insurers and loss adjusters are likely to rely upon as they try and process thousands of claims. We provide guidance on dealing with information requests, including advice on whether insurers' requests are reasonable and necessary. It's likely insurers will require claimants to provide factual information about how COVID-19 has impacted them. We need to, however, to avoid information paralysis. We need to focus on what's important and what's relevant. We then negotiate with insurers on your behalf to achieve expedited and cost-effective resolution by leveraging our relationships and minimising the external legal costs associated. No pun, Mark. In many instances, the coverage limits may be significantly less than the loss experienced. How can a claim be expedited in these circumstances? Next slide, Tim. Our forensic accounting team can help you communicate your financial loss to COVID-19 insurers. We understand numbers and we know how to align your financial loss with the coverage provided under the policy. Our forensic team can help you to communicate the financial impact of COVID-19, provide what-if analysis to help you understand how to maximise your claim and to manage your internal expectations. We can prepare high-level estimates to accompany notifications whilst you seek indemnity. And we can then work towards formulating detailed claim submissions, which deal with financial loss modelling that's aligned with policy requirements. We can also help you prepare causation matrices to support your claim and link the financial loss to the causation drivers. We will also ensure that we align or allocate those losses based on heads of coverage, and if required, splitting between insured and uninsured elements. We'll also help you to respond to the proposed adjustments by loss adjusters, including rebuttal or alternatives or being able to distinguish on the facts. And it's important to remember that our fees are often covered under the policy, and therefore there's often no cost to you. Next page, Tim, please. So in summary, there's likely to be a huge number of claims which are lodged with insurers. They're likely to struggle with dealing with all this volume. It's likely they're going to rely on automated claims models or claims models which have a number of artificial intelligence elements to them to process these claims. Therefore, these models that they use may not fit your loss circumstances. Insureds are likely to need assistance to maximise their recovery, to distinguish their facts from the way the insurers might be trying to resolve the issue. As Mark has identified, once identity or coverage is confirmed, there is still a need to address a number of issues, and insureds are likely to need assistance to respond to these proposed adjustments. The Claims Solutions practice is here to support you, our Marsh clients. We're here to work with the whole Marsh team to maximise your recovery and expedite the claim resolution process. Thanks, Tim.
Thanks, Luke, and thanks, Mark, for your analysis and oversight. And clearly, look, what we've been hearing the last 50 minutes, if we thought we were sort of near the end of a long road in terms of COVID determination, this really indicates that we feel like we're only at the beginning. So I'd just like to conclude before we sort of go to some Q&A session, just with some pointers on sort of what we would be looking at moving forward. So I think it's obviously really important for all of us. So our clients, the brokers, our business, really it's a partnership, and it's us working with you to review your individual policies. They're all slightly different in many cases, and really identify all the relevant provisions and discuss with you the impact of those provisions, and point out to you, the potential arguments that the insurers are going to raise. They're going to look at, the many arguments around prevention of access and disease that, Mark's outlined, and think of corresponding arguments which we have to respond to. Obviously look at, I think, best position is really not to engage in sort of hypothetical claim discussions with insurers at present. It's really present the case of your individual circumstances, and then seek some guidance from the insurers as we move forward. I think secondly, it's very important to report potential claims promptly. Marsh is the biggest broker in Australia. We've received, as you saw on the first slide, 700 claims to date, of which about 140 of them are directly related to property or BI losses. There are more out there. We know that, and it's very important that we see them, that we help you file those claims, have those discussions with insurers and underwriters, and make sure it's presented in the best light that we can. We've heard from Luke about the services that Claims Solutions can offer you, whether it's from a forensic accounting perspective and preparing the loss scenario and the modelling, or more from a coverage perspective and the utilisation of our claims advocates, the best in their fields in terms of analysis of many of the wordings and of the policy, and presenting your case to the insurer in the best possible light. We think it's important that you don't do this alone. We have technical resources here at Marsh that we are happy to share with all our clients and customers. In circumstances, it's very appropriate to also consider retaining coverage counsel when appropriate. Someone like Mark is happy to put up his hand and walk you through the complexities that we have. So I would strongly urge you, if you have any queries or questions, please reach out to your Marsh broker, the Marsh claims team, and we are more than happy to assist and guide you through the next 3 to 6 to 9 months, the time taken to get through this process. So we've got some questions. That sort of brings an end to the formality of the proceedings, but we have some questions which have been coming through. We've got sort of 5 minutes left before the top of the hour. We'll try and tackle as many as we can. For those that have sent them through during this call, we will respond to those and send through a copy of the recording. But Mark, I'll start with you because there's a lot of interest, obviously, from the legal side of the house. But there's a question here which is in relation to the UK Supreme Court and the findings. So, will the decision of the UK Supreme Court be binding on Australian courts? And if not, what real relevance do the UK proceedings have for Australian policy holders? You're on mute, Mark, so I'm sure you're saying something that is incredibly valuable.
Sorry,
and I want to hear
rookie error. The short answer is it's not binding on the Australian court, but will be influential. I think in 1976 or thereabouts, English courts stopped having a influence on Australia, or a binding influence on Australian courts. But if the UK, 5 judges of the UK Supreme Court made a decision, if it was 5-0, it would be more influential than 3-2. And London being the sort of hub of insurance, you'd expect it would be influential, but there might be reasons why the law is accepted, but for factual reasons, cases are distinguished here. So if everything goes according to the way it was currently held by the High Court, then obviously there's a lot more positives for policyholders here, and they've just got to make sure that they can weave their way through the factual differences. Okay,
thank you. There's a question here, Luke, which I'm certainly happy to help to answer with yourself, and it's in relation to claim submissions. So, what level of detail should I include in my notification? I think that's a great question. So, thank you. And from my perspective, I'm sort of a little bit apprehensive that people think, well, look, I've suffered a business interruption loss. It's been some time. I've got to get all the numbers together. I've got to get my accountant in. I've got to certify records. It's going to take a long time before I can present a full case. What should I do? My advice is to get it in as quickly as you can, and we can flesh out the details as we work through that. But it's just important to get that claim notified to the underwriter. Luke, what are your sort of thoughts around that as well?
No, I agree completely, Tim. I think it's important to get the notification in. And I think that you either don't want to cause a delay, or also it may be that you actually provide the wrong information. So it may be in the first instance that you're notifying without a lot of detail in regard to the financial loss.
Yeah, no, I agree. I've got a question here for Mark. Why would a body like the ICA run an action that challenges the Quarantine Act issue when other exclusions are obviously being relied upon by insurers? And what about the second test case? Are we going to see a second test case? How long will it take? So there's about 3 questions in there, Mark. Sorry.
Oh, look, I think to answer why they ran it, I think they thought it was a pretty good point, and that they would be able to knock out a large portion of claims. I mean, they already knock out on the outbreak exclusion, on the outbreak trigger, policies which refer correctly to the Biosecurity Act exclusion. There was obviously a body of policies that had the outbreak trigger, but referred to the wrong act, and they thought, I think, that this would be a quick win that they could get to knock all of those claims out, and then they thought they'd be left with the prevention of access and closure by authorities type clauses. Remember, when they started their test case, the judgment in the ICA case hadn't come down, and they probably thought that under the OEH principle that they were not at risk for the wider impacts of the pandemic and the actions by authorities. So looking at it back now, they probably went a bit narrow and thought that they'd have a win in London and wouldn't need to worry about other things. I'm not sure whether they'll do something similar to what we did in London over here. You know, there's all talk about it. I mean, there's a lot of ambulance chasers out there talking about class actions and what have you. I just don't see that this is really a class action because of the number of different policies and the different circumstances. So it's more of a test case. Whether ASIC gets involved and has some sort of tribunal that tries to deal with it, I'm not really sure. But while we're just putting out bushfires, pardon the pun, everywhere and all of this, it's going to be a bit of a dog's breakfast to try to get a handle on.
Okay, good. Thanks, Mark. Well, look, everyone, that brings us to the top of the hour. Look, I've received a lot of great questions here. Francis, thank you. Fiona, Vlad. Look, we will respond to all those questions. So we'll come back to everyone with a copy of a recording of this just to share with colleagues, obviously reflect and review some of the comments, and Mark's provided a lot of detail around that. And also to respond to each of the questions that you've raised with a written response. So that will come out within the week. But I'd like to thank obviously Luke and Mark for their time this afternoon. Very, very insightful. I'd like to thank you all for attending. I hope you received some sort of insight and guidance. But my last words to you all is, look, please reach out to your broker, reach out to the Marsh Claims team. If you have any queries, questions, we're happy to help. We're here to help, and I'm sure we can partner together and move forward with this very quickly. So thank you all this afternoon, and we'll bring the webinar to a close. Good afternoon, everyone.
Thank you.
Thank you.